When Aretha Franklin died in 2018, her family believed one thing was certain: she had left no will. Her estate, initially estimated at around $80 million, would be divided equally among her 4 sons. Simple, clean, final. But about 9 months later, someone checked the couch. Not a safe, not a bank vault, not a lawyer's office. A couch. Tucked inside a spiral notebook, hidden beneath cushions where guests once sat, was a handwritten document dated 2014 that would ignite one of the most shocking inheritance battles in modern celebrity history. A document that would pit brother against brother, put Aretha Franklin's private life on public trial, and force a jury to answer a question no family ever wants strangers deciding. What did she really want after she was gone? Because by the time the verdict came down in 2023, the damage was already done, and it all started with a couch. Aretha Franklin wasn't just famous, she was the queen of soul, a woman whose voice reshaped music, whose songs became civil rights anthems, whose career spanned over 5 decades. She won 18 Grammy Awards, sold more than 75 million records worldwide, and built a legacy so powerful that even her silence commanded respect. But if there was one thing Aretha Franklin guarded more fiercely than her voice, it was her privacy. She avoided interviews. She distrusted outsiders. She kept her personal life tightly controlled. Friends described her as intensely private, sometimes secretive, often stubbornly independent. And that trait, more than fame, more than money, would shape everything that came next. Because when it came to planning her estate, Aretha Franklin did things her own way. Or not at all. When Aretha Franklin passed away at age 76 on August 16, 2018, she left behind an estate initially estimated at around $80 million. This wasn't just cash. It included music royalties still generating income, intellectual property rights, personal belongings, and multiple homes, including a valuable property in Bloomfield Hills, Michigan. It was the kind of estate that demands precision, lawyers, clear documents, no room for ambiguity. But when her family searched for a formal will, they found nothing. No typed documents, no attorney-filed paperwork, no official estate plan. Legally, that meant one thing: Aretha Franklin had died intestate, and under Michigan law, that meant her fortune would be divided equally among her 4 sons. At least, that's what everyone thought. Aretha Franklin had 4 sons, each one different, each one connected to her in complicated ways. There was Clarence, her eldest, who required long-term care due to special needs. Edward, private and largely out of the spotlight. Ted White Jr., also known as Teddy Richards, named after Aretha's former husband and a musician who played guitar with her. And Kekau Franklin, the youngest, who had remained closely involved in her life. They shared a mother, but not the same upbringing, not the same experiences, and not the same expectations. At first, there was no public feud, no headlines, no accusations, just a quiet assumption that the law would handle everything fairly. But behind closed doors, something was happening. Someone was still searching. Through drawers, through cabinets, through personal belongings Aretha never expected the world to see. And eventually, that search led to a discovery so strange, so informal, and so controversial, it would rewrite everything the family believed about her final wishes. Because the will they were about to find wasn't in a file, it wasn't in a safe, it was hidden in the last place anyone thought to look: under the couch. After Aretha Franklin's death, her home in Bloomfield Hills became more than just a place of mourning. It became a question mark. Family members, attorneys, and court-appointed administrators began doing what they had to do, cataloging her belongings, securing assets, and searching for anything that might clarify her intentions. At first, it was routine. Drawers were opened, file cabinets were checked, locked spaces were inspected. Still nothing. No formal will, no signed legal document. As the months passed, the assumption hardened into fact. Aretha Franklin had simply never written one. And for a woman known for control, that alone was shocking. But then, in May 2019, almost 9 months after her death, something surfaced. A handwritten document was discovered inside a locked cabinet. It wasn't typed, it wasn't notarized, though signed on each page, but it was unmistakably written in Aretha Franklin's handwriting. The date at the top read 2010, specifically June 2010, with another page from earlier that year. This document laid out instructions for how her estate should be divided. At first glance, it seemed reasonable. The estate would be shared among her sons with provisions for Clarence's care. But there was a catch: conditions. Some provisions required certain heirs, Kakoff and Edward, to meet specific educational or business qualifications before inheriting. And just like that, the calm was gone. Because handwritten wills, known legally as holographic wills, can be valid under Michigan law, but they are also notoriously easy to challenge. And this one raised questions immediately. Was it finished? Was it meant to be temporary? And if it was written in 2010, why had no one ever seen it before? Still, this appeared to be the answer everyone had been looking for, until another discovery made it clear. This was only the beginning. While reviewing Aretha Franklin's home again, a family member, her niece Sabrina Owens, noticed something unusual. A spiral notebook, worn, unassuming, not stored in a drawer or cabinet. It was found beneath the cushions of a couch. Inside that notebook were more handwritten pages, again in Aretha Franklin's handwriting. This time, the date was March 2014, 4 years newer than the first document. The instructions were different, more direct, more personal, and far more controversial. One son, Cal Franklin, was given a major advantage, including rights to the Bloomfield Hills mansion, the crown jewel of the estate, for him and his children, Aretha's grandchildren. The same mansion where the notebook had been found. The implications were immediate. If this document was valid, it would override the earlier will. But the way it was written raised alarms. Words crossed out, sentences squeezed into margins, signatures that some claimed were unclear, though it ended with her name and a smiley face in the A. And the location. That detail alone would define the case. A will hidden under couch cushions, not in a safe, not with an attorney, but in the most ordinary place imaginable. Some saw intention, others saw chaos. And before the family could even process this discovery, the battle lines were drawn. By the time the dust settled, the estate wasn't dealing with one will, or 3 minor variants, but 2 primary competing handwritten documents, written at different times with different instructions, each one claiming to represent Aretha Franklin's true final wishes, each one worth millions of dollars. What began as a simple inheritance had become something else entirely, a legal maze, a family fracture, and a question no document could easily answer. Which version of Aretha Franklin should the law believe? The private icon, the meticulous artist, or the woman scribbling final wishes into a notebook she hid beneath a couch? Because soon, the family would stop debating behind closed doors and take their fight into a courtroom, where strangers would decide what family could not. Once the reality set in that there were 2 competing wills, the family stopped speaking in generalities. They started choosing sides. What had once been quiet disagreement hardened into positions, legal positions. One camp, led by Kekauf and Edward, argued that the latest will, the one found beneath the couch cushions, must be honored. In probate law, timing matters. A newer will usually overrides an older one. And this document was dated 2014, 4 years after the first. To them, the case was simple. Messy or not, unconventional or not, this was Aretha Franklin's final word. Those opposing the couch, led by Ted White Jr., focused on one thing: credibility. They questioned why a woman with millions of dollars, access to top attorneys, and decades of business experience would hide her final wishes in a couch. They pointed to the document itself. Words crossed out, sentences crammed into margins, handwriting that varied in pressure and spacing. Some pages were signed, others were not. To them, this didn't look like intention. It looked like confusion, or worse, something unfinished that was never meant to be final. And as lawyers examined the pages line by line, the tone of the dispute shifted. This was no longer about interpretation, it was about validity. At the center of the argument was property, the Bloomfield Hills mansion, a valuable home tied not just to money, but to memory. The couch will granted that house to Kekauf Franklin and his children. To supporters, this made emotional sense. Kekauf had remained close to his mother. He had spent significant time with her in later years. He knew the home. To critics, it raised suspicion. Why him? Why that property? And why in a handwritten note hidden away? When millions of dollars are involved, motives are scrutinized. Every relationship, every visit, every detail of the past, even silence became evidence. Hovering over the entire dispute was a question no one wanted to answer publicly, but everyone understood privately. Clarence Franklin, Aretha's eldest son, required long-term care. Both wills included provisions for his support, with the 2010 version more detailed. A separate settlement ensured Clarence received a percentage regardless of the outcome. But unclear documents risked destabilizing everything. And suddenly, this wasn't just about fairness, it was about duty, about who would be responsible, and whether Aretha Franklin had truly made her intentions unmistakable. As tensions rose, attempts at private resolution quietly failed. Lawyers stepped in fully. Motions were filed. Arguments were formalized. What had once been a family matter was now headed somewhere irreversible. A courtroom, a jury, and a verdict that would not only decide who inherited what, but permanently place Aretha Franklin's private thoughts under public judgment. Because the next phase of this story wouldn't be decided by family loyalty, it would be decided by strangers. And once that happened, there would be no taking it back. By the time the case reached Michigan Probate Court in July 2023, the emotional distance between the brothers was complete. This was no longer a conversation, it was a contest. The court was now responsible for answering a deceptively simple question. Did Aretha Franklin leave a legally valid will? But behind that question were dozens of others. Which document mattered most? Which version of Aretha Franklin should the law recognize? And how much imperfection is allowed when millions of dollars are at stake? Because in probate court, intent matters, but proof matters more. The battle quickly narrowed to a technical battlefield: handwriting. Experts were brought in to analyze the documents. They examined letter shapes, pen pressure, stroke patterns, consistency across pages. Page by page, line by line, the wills were dissected. Some experts testified that the handwriting matched known samples of Aretha Franklin's writing. Others pointed to inconsistencies. They questioned uneven signatures, abrupt line breaks, variations that suggested haste or fatigue. Every smudge became significant. every crossed-out word was debated, because if the handwriting was authentic, the couch will stood a chance. If not, it would collapse. But handwriting alone wasn't enough. The court needed to understand intent. Supporters of the couch will argued that Aretha Franklin was known for doing things informally, that she distrusted lawyers, that she preferred handwritten notes, that she revised her thoughts privately. They claimed the document's imperfections were proof of authenticity, not weakness. Opponents countered with a different narrative. They argued that the disorder showed the opposite, that this wasn't a finished will, that no reasonable person would treat such notes as final instructions, and that hiding them under a couch suggested uncertainty, not clarity. The courtroom listened, and slowly the focus shifted from money to mindset. Then came the most uncomfortable part. The family testified. Brothers described their relationships with their mother, who she trusted, who she relied on, who she spoke to in her final years. Some testimonies were measured, others were emotional. What was said mattered, but so did what wasn't. Pauses, hesitations, carefully chosen words. For the first time, Aretha Franklin's private family dynamics were being weighed, not by fans, but by jurors, and the room felt it. As the testimonies concluded, one thing became clear. This case would not be decided by celebrity. It would be decided by credibility, by whether the jury believed that a woman as iconic as Aretha Franklin could also be deeply informal in her final moments, by whether a couch could hold something as serious as a last will. And as the court prepared to send the case to the jury, one question hung in the air. Were those pages under the couch a mistake, or her final, unmistakable voice? When the final arguments ended, the courtroom fell into a different kind of silence. Not dramatic, not emotional, heavy. The judge gave the 6-person jury their instructions. They were not being asked to decide what was fair. They were not being asked what they would have done. They were asked one thing only. Did the 4-page handwritten document dated March 31, 2014, found in a spiral notebook wedged beneath couch cushions, meet the legal requirements of a valid holographic will under Michigan law? Then the jury stood and left the room. For the family, the waiting began. The deliberation did not last long. In fact, it lasted less than an hour. To some, that suggested clarity. To others, inevitability. Outside the jury room, lawyers prepared for either outcome. Inside, 6 strangers reviewed handwritten pages that had never been meant for them, words scribbled in private, decisions made without witnesses, a woman's final intentions reduced to pen strokes, dates, and then the door opened. The jury returned to the courtroom. Everyone stood. The verdict was read. The handwritten will found beneath the couch cushions was valid. In a matter of minutes, the direction of Aretha Franklin's entire estate changed. The 2014 document superseded the earlier 2010 handwritten will found in a locked cabinet. Its instructions would be followed, and one son, Cacao Franklin, was now legally entitled to the Bloomfield Hills mansion, along with provisions for his children, Aretha's only grandchildren. There was no celebration, no visible relief, just stillness, broken only by hugs from the grandchildren to Cacao and their uncle Edward. Because even when a verdict is clear, its consequences are not. Legally, the decision settled the central question, but emotionally, it opened others. The ruling confirmed that handwritten, holographic wills can carry full legal weight in Michigan. Informality does not invalidate clear intent, and privacy, when paired with ambiguity, can become dangerous. The court later upheld the jury's decision. The case moved toward final settlement, but the relationships at its center would never return to what they were before. Aretha Franklin's voice had once filled stadiums. Now her handwriting had filled court transcripts. A few pages, hidden beneath cushions, had been elevated to the final authority over her legacy. And while the law had spoken, the question remained unanswered for many watching from the outside. Was this truly what she wanted? Or was this the cost of leaving certainty to chance? Because when the jury reached its verdict, they decided more than an inheritance. They decided which version of Aretha Franklin the world would remember at the end. On July 11, 2023, after less than an hour of deliberation, the jury delivered its verdict. The 2014 couch will was valid. It overrode the 2010 document. The court enforced the jury's decision. Property ownership was finalized, including the Bloomfield Hills home to Kickoff and his children, other properties to Edward and Ted. The estate began closing the final chapters that had remained open for years. On paper, the matter was resolved. But families don't operate on paper. The brothers had spent years questioning each other's motives, testifying under oath, letting lawyers speak where trust once existed. Even as the estate settled, the emotional cost lingered, because winning a case does not always mean winning peace. And for a family already shaped by fame, pressure, and loss, the courtroom had become another dividing line. Aretha Franklin's musical legacy remains untouched. Her voice still defines generations. Her songs still fill radios, films, and history books. But her final chapter tells a quieter, more cautionary story, one about control and what happens when it slips. Despite her power, influence, and wealth, Aretha left behind uncertainty, not because she didn't care, but because she trusted privacy more than process. And that choice placed her most personal decisions into the hands of strangers, a jury, a judge, a legal system built to interpret intent, not emotion. Inheritance battles are rarely about money alone. They're about recognition, about fairness, about who feels seen and who feels forgotten. Aretha Franklin's case proves something uncomfortable. Even legends can leave confusion behind. Even handwritten words can become weapons. And even love, when undocumented, can turn into litigation. The couch will wasn't shocking because of where it was found. It was shocking because of what it forced her family to do afterward. The jury delivered a verdict. The law did its job. But history leaves us with a question no court can resolve. Did the couch will reflect Aretha Franklin's true final wishes? Or was it simply the last version of thoughts she never meant to finalize? That answer may have died with her. And perhaps that is the most human part of this story. Aretha Franklin once sang about respect. In the end, her estate battle reminds us of something equally powerful. Clarity is respect for your family, for your legacy, for the people left behind. If this story made you think, comment below with your verdict. Was the jury right, or should Aretha's fortune have been handled differently? Like the video, subscribe to Inheritance Verdict HQ, and join us for the next real inheritance story, where the truth isn't decided by fame, but by the fine print.